When you need an attorney, how do you want to feel? Confident that the guy's going to take care of you, guy or the gal. Going to take care of you. You're in good hands because you're in an arena where the outcome typically is very, very influential in your life, and you're in an arena you know nothing. Mark Chuparkoff is that man. He fills you with confidence. He says all the right things. He makes you feel comfortable that he's going to take care of you. This here is Mark Chuparkoff, an attorney from Columbus, Ohio, residing in Dublin. Beautiful home, beautiful wife, great career, and he can just persuade you. But things aren't always what they appear. This also is Mark. Now, what happened to Mark? He didn't look like he did before. Mark had a promising practice, had a partner, things were going good, and then his demons came out. Can't say whether Mark, what his true demon is. We do know one is drinking and driving. Got arrested for a DUI in early 2017. So typically when somebody gets arrested with a DUI, this is at a point where his things weren't going so well for him. But it's usually not their first time drinking and driving. Could be his first time, but usually it's not. In 2015, Mark Chuparkoff had his law license suspended due to back child support. And then 2016 January, it was reinstated. He was back in the saddle again. But Mark had bigger problems in front of him. This is the first page of a 60-page report done by the Board of Professional Conduct, as they reviewed many customer complaints, client complaints about Mark's professional behavior. And this was issued in November of 2016, and in this 60-page report details some of the things that Mark did and what eventually led to his license being suspended again. So it was suspended the first time in December 2015, reinstated about a month or so later, but then in the end of 2016 it was suspended again. What did Mark do? Well, we got a DUI, but was that it, or was there more? As you can see, in July 2016, they called for a suspension again, and August 19th, 2016, his license was again suspended. Now, I'm not going to go through every one of these client complaints and the nuances and the details, because it's just way too long. I want to give you a good, brief overview of Mark Chuparkoff and why you should be concerned if you ever interact with him on any business level, and on any level, in fact. So, I'm going to give you an overview here. What did Mark do? Well, Mark took money from customers, clients, deposited the money into, in this instance, into his escrow account, and instead of withdrawing it for earned fees, expenses associated with the case, Mark deposited the money into his account and quickly used it for personal and business expenses before it was earned. In another case, Mark made a settlement with a opposing counsel, and he sent the settlement proceeds to the client and kept money for himself. However, he didn't pay off the debt that was supposed to be paid, or the lien, for the customer. So he retained that. Did not pay off all the proceeds, or the proceeds did not go to where it was supposed to go, leaving the client stuck with a lien. Mark would take retainers from his clients, but then he wouldn't do the work. Here they talk about him has failed to respond to discovery requests from opposing counsel, even after the court had issued multiple orders compelling him to do so. So he just didn't do the work on the case. With other clients, he just, he failed to provide them accounting of the funds and how they were spent. Didn't refund any unearned funds, and refused to give a copy file to the client. With another client, as it states here, he was given a $25,000 retainer. $25,000 retainer, $25,000 in advance. Ugh. If you look at down here at the very bottom, he still failed to respond to discovery responses. So the guy's been given $25,000, but he can't do anything. He's not responding to the basics, discovery. Jesus. Now here's this poor guy. The guy gets, he could have been guilty, maybe not. I mean, let's assume that he's, give him the benefit of the doubt, say he's innocent. That's how Mark should have been looking at it. But here's a guy who's in jail for 9 years, and he was appealing his case, and he took out a loan to give Mark $1,500 to work on his appeal. And over a month, Mark's just not getting back to him. Here's a guy sitting in jail, borrowed $1,500, and is worthy enough to be in here for the complaint. Mark just doesn't respond. 60 pages. We could go on for hours, but here's an article from Akron Legal News, which really kind of sums up Mark and all these complaints, all these customers, all these clients that he had. Sums up his situation pretty neatly. Mark was deemed to pose a substantial threat of serious harm to the public, and they're quoting what they're doing here. They're quoting the court. Moreover, despite an ongoing investigation, Chuparkoff's misconduct has continued unabated. The memo describes Chuparkoff's habits of misleading clients into thinking he was working on the files when the clients were the ones holding up the process. So, here's a classic manipulation, and blaming the person that you're dealing with of doing exactly what you're doing. Because Mark would take retainers and then just not do the work. Well, what Mark would do is he would blame the client. He would blame the client for why the case wasn't moving forward. You're not doing what you're supposed to do. Horrible. But the biggest thing here is the high court suspends lawyer deemed threat. Poses a substantial threat of serious harm to the public. And if you talk to Mark and you met him, you think he's the greatest guy in the world. But the court has it right. Of course, Mark has personal financial problems, tax liens, child support payments past due, and it was suspected that Mark has a problem with alcohol or gambling, or maybe both. Well, gambling, drinking's an issue. He had a DUI. But the dinger, the one that put him away, is Mark had a surefire way of making some good money. He'd get a settlement, but then wouldn't give his client any money, like what he did here. He settled on this case here. Never told the client that there wasn't any settlement. Never told him. And he took the full $75,000, which put Mark away in jail. He pled guilty. He didn't go. Pled guilty. And was charged with multiple felonies, and went away for X amount of time. Not even sure how long he got. But disgraced Ohio lawyer charged with stealing client's $75,000 settlement. He just didn't tell the client that there was even a settlement. That's what he did. Having experienced myself, although I didn't make it into the complaint, much of these things with Mark when he represented me, I went to see Mark in jail lost a lot of weight. Didn't have, they probably didn't have access to all the booze that he had on the outside, although they make some inside. But Mark had lost a lot of weight, but he was upbeat. He was cheerful. Sat down in a booth just like this, talked to him, and Mark was very, very upbeat. And in fact, Mark really hadn't lost a step. The only thing he'd been done is been put in jail. Why do I say that? Well, as I sat there and spoke to Mark, he started to bring up my cases and did the same thing. Started to blame me for the downfall of my files, my cases. But he did the same thing. He took retainers and he didn't do anything, and he told me it was my fault. While in jail, he continued to tell me it was my fault. And he continued to tell me all the cases that he had dealt with. None of them were his fault. None of them. None. No remorse. No admission of guilt. None. Mark actually liked telling me that how well he was doing in jail. He fit right in. Things were great. He's a person to tell you, that everything's cool. He's cool as a cat, and things are great in there. Maybe he made some friends. But the one thing for sure is that, speaking to Mark, as he sat there and convincingly, as convincing it can be, knowing that I know that he's lying when he's talking, telling me why my cases didn't do well was because of me, which is what he tells everybody. But it told me that Mark's little timeout that he was put in really didn't teach him anything. So he may get out, he may get his law license back. And he's still dangerous. He's still going to be a threat because he didn't learn anything. He didn't admit anything. Everybody else was at fault. Everybody else was wrong. The judge was wrong. The judge was wrong. Everybody was wrong. Not Mark, though. His timeout didn't help him. So if Mark gets out, comes to your place of employment for a job, or if he wants to have you as a client, you can look up his record. You can read the 60 pages. You can read the detail of what he did and how he manipulated, how he worked person after person. This is the Mark you should remember. On any level you associate with Mark, he's a dangerous man. Be careful.